Everybody, and thanks very much for coming today. Firstly, I'm sorry that the screen is a shade of green. We're not entirely sure how that's happened and we can't seem to fix it. So there are hard copies of the presentation on the seat, so it might be easier to use that. Right, a little bit about me. I'm a solicitor at Irwin Mitchell Solicitors here in Sheffield. I'm an education lawyer, so I practice largely in education law, advising parents, young people, even schools. So I know a fair bit about what's to come, and the purpose of my presentation really is to try to give you a bit more of the nitty-gritty details of what's to come. So far as we can at this stage, because of course we heard earlier on that the SEN Code of Practice is in the process of being rewritten, the regulations haven't yet been finalised, although we do know that the legislation was given royal assent yesterday. So I will try my best to provide what information I can, and then of course at the end very happy to sort of open it up to questions and answers and see what further information I can provide there. So let's get started. Are most of you parents, by the way? Parents or yeah?
I'm parent and a teaching assistant.
Right.
Yeah.
Okay. I mean, this talk is really focused largely, I think, for parents, but I'm sure it'd be very helpful for anyone who's here. Right. Okay. I just thought I might just give a bit of an overview about what the Children and Families Bill covers, because it's not just special educational needs, it covers a whole host of topics. So we've got adoption and looked after children, family justice, childminding, all of these subjects here. And if anybody is interested in finding out more about any of these particular topics, it's not actually covered in this presentation, which is all about SEN. There is a very useful fact sheet that the Department of Education has produced that's available on their website. It's a 2-page fact sheet, and it just runs through a little bit about what's covered in the bill itself. The special educational needs is only one aspect of it. I thought it might be helpful just to start off by just running through where the law is at the moment, because all of this is going to be abolished as of 1st of September. Well, most of you are probably familiar with the Education Act 1996, that's where a lot of the primary stuff is. The regulations, the Code of Practice as we know it at the moment, and the Learning and Skills Act, which deals with post-16 education, so learning difficulty assessments when children leave school and they go to college. And as things stand at the moment, if a child has got a statement, it will carry on until the age of 19 whilst they remain in school, and parents can appeal to the tribunal if there's a dispute about parts 2, 3 and 4 of that statement. And then of course we've got section 139A, which is about the learning difficulty assessments, which essentially replaces statements when children leave school. And they continue until the age of 25. Now, the thing about that is that it's a little bit disjointed. So you've got statements until 19, and then it moves over to a learning difficulty assessment. And as things are at the moment, once a child leaves school and they've got a learning difficulty assessment, and there's a dispute about the content of that, you can't appeal to the tribunal. You have to go through the local authority's appeals process, and if you've reached the end of the road, the only remedy available to parents is a judicial review in the High Court, which can be quite intimidating for parents to have to go through. So one of the things which we'll discover later on is that this new legislation sets to eradicate these two differences in the process and streamline it all. Right, so what's actually brought about these changes? I apologise if some of this was covered in the earlier sessions, but I think a lot of it stems from the Lamb inquiry. The government commissioned an inquiry into SEN parental confidence, which started quite a few years ago now, in March 2008, because there was a lot of talk about from parents being very dissatisfied with the current system, not really knowing what their rights were, the system not being ambitious enough for their children, and thousands of parents contributed to that inquiry. The final report was published in December 2009. And what the inquiry did was it made a total of 50 recommendations on how the current framework needed to be improved. And what the inquiry said was that major reform was needed, and it was needed urgently, although that was 5 years ago. And the two main strands to come out of the inquiry from contribution from the parents was that what we needed was more focus on giving parents a voice that's actually not just going to be heard, but it's actually going to be used in the decision-making process. Because I think a lot of parents, and you probably know this yourselves, feel like your views, and you know your children best, aren't really being heard, and your children are being put in schools and just being told that this is what your child's going to get and no one's really listening. And that the system wasn't ambitious enough for children. So that they were the two main strands that came out of it. So the government sort of got on and started to see what it could do to rectify this, and decided that actually the whole system needed total reform, and the way in which it was going to do this was to abolish all the current legislation and redraft it. So that's how the Children and Families Bill came about, and in addition to that, we've got regulations, and then we've got the new SEN Code of Practice, which is just draft at the moment. So that's essentially what's going to replace the current system, so those three strands. I think that the important point to mention about the Code of Practice is that it is statutory guidance, and so it does have the effect of law, essentially. So local authorities and other bodies have got to comply with it unless there's a good reason not to. A little bit about the timeline. This just sets out a bit about the background and where we started off. At the moment, we're sort of at the Royal Assent stage, because we know the legislation received Royal Assent yesterday. And as I understand it, everything's set for implementation 1st of September. I think there were some concerns that, is it going to be implemented on time, are there going to be any delays? But it does seem as though everything's on track and it's all going to be ready for implementation. And certainly what we heard this morning as well. Right, who is covered? A child or young person with special educational needs. So it's going to cover now children, which are children from 0 to compulsory school age, and then young people up to the age of 25. So essentially it's 0 to 25. The current system does cover up until the age of 25, but it's in that sort of fragmented process where you've got the statements and then you've got the learning difficulty assessment. So this is just going to be one system now, 0 to 25. I should probably say, as we're going through this, if there are any questions, you're very welcome to ask me, otherwise we can save them until later.
Sorry, very briefly, what happens to young people who currently are coming to the end of their statement, say around 17, and then in September the new EHC plans come in? Would those young people have a case for converting their statements into an education health and care plan in order to sort of continue their provision, special needs provision up until they're 25?
I think so, and I think Alistair answered that question in a roundabout way earlier, because actually the criteria for a statement is exactly the same under this new legislation. So if a child has got a statement now or a learning difficulty assessment, there's no reason to time conceive why somebody wouldn't be eligible for one under this new system.
I just heard some publicity which suggested that would be very unlikely that young people around 16, 17 would be able to convert their statements to HC plans. Do you think if it went to tribunal or court that the young person would win?
Well, I think so, because if they've currently got a statement and their needs haven't changed, then I can't see any reason why they wouldn't be eligible for one. I think if their needs have changed and they suddenly say this new system, this current system continued, there's always the option to discontinue statements, or discontinue learning difficulty assessments if the child or young person doesn't need it anymore. But if the needs are exactly the same, I can't see why they suddenly couldn't get one. I'd be very concerned actually if that was the case, because that's not what this system is meant to be achieving, really. I hope that answers the question.
No, that's great.
Right, so I've listed here what I think are the key changes from the current system to the new system. School Action and School Action Plus is going to be replaced now with equivalence. So in effect it's not really been abolished, it's just been given a new name. The other thing is about the school funding regulations. This actually doesn't really come about from this new legislation, but the Department for Education brought into effect school funding regulations, which came into effect in April last year. And essentially what that means now is that the Department for Education sends money directly to schools, so this is academies and local authority schools, to meet the needs of children with special educational needs. And schools now are expected to provide the first 4,000 for a child without a statement, and then 6,000 for a child with a statement, and this would presumably apply with the new EHCP plans. And anything over and above that, that's needed by the school. The local authority has a top-up fund. I think it's quite important just to spend a little bit of time just dealing with this, because I don't know if there are any teachers here. I think there was one teacher, but there was an article in The Guardian not so long ago, I think it was just before Christmas, where schools were sort of raising concerns that they were really struggling to meet the needs of children in their school under this new regime, and they just literally did not have the money. I think that if you're a parent of a child and you're faced with a school saying, look, you know, we really can't meet the needs of your child under this new regime, and therefore we think that your child needs to move on to another school. I think the thing to make the school aware of, although I would hope that they are already aware of it, is that they can apply to the local authority for extra money, because the local authority has got a big pot of money that's essentially a top-up fund. So if any school needs anything more than that 10,000, they can apply to the local authority. And I have seen cases where schools don't seem to be aware of this.
No, I've been told there's no extra money.
Right. Well, I'd be very
concerned. Can I go back to them and tell them?
Yes.
So they go to the local authority to apply for this?
To the local authority, yes. The local authority have got a budget to top up that £10,000. And I think it's very unfortunate if children are getting caught up in between disputes with the school and the local authority. Quite often I think local authorities will say, well, you should be able to meet the needs of this child with the £10,000 you've got. But if the school is saying, look, we really can't, and the school probably knows best because they're teaching the child on a daily basis and understands them probably better than the local authority, the school really needs to get on and ask for the local authority to provide that additional funding. And if they don't, you can complain. You can complain to the Department of Education. In extreme cases, you can consult legal advice.
Is that just a mainstream or special schools?
It's any local authority school or any state school, so it would be mainstream schools, special schools, and also academy schools. So although they're independent, they are independent state schools. It doesn't apply to fee-paying independent schools because they're expected to meet the needs of the child from the fees that they get when a child is enrolled at the school. So that's something that I have come across quite recently, so I thought it might be useful just to mention that, because it may become more of an issue as time goes on, as schools are starting to get used to these new changes and with the new changes on the 1st of September. It's going to apply to academies, independent schools and colleges, and all of these schools are going to be required to admit the child when it's named in the EHCP. So there's a duty there. You know, the schools have got to admit that child. I know sometimes I see schools, you know, sort of say, oh, you know, we really can't admit your child because we just haven't got the resources. We've got lots of SEN children already on our roll. And I think some schools are relying on these new regulations as well about funding. But if the local authority names that school, they've got to admit that child.
Can I just ask something there?
Yes.
Because that was something I picked up from what Alistair said this morning. Because he said, oh, they have to, they've got duty code, they have to admit. But then he followed it on to say, unless, he said there's a, you know, there's a few occasions, you know, when that might not be possible, and one of them, of course, was value for money, which sort of, for me, immediately puts in some legal grey area. So if they can make a case that it's not value for money, and what does that entail?
Value for money for who? Because if
Well,
the
he
local
didn't say
authority...
that either. I
Yeah.
perhaps interpreted that.
So, yeah. Yeah, I mean, I think under the current scheme, if a local authority plans to name a school in the statement, they have to embark on a consultation with that school, send the statement and say, you know, we'd like the child to possibly attend your school. What do you think? Do you think you can meet the needs in this statement? If the school comes back and says, yes, that's absolutely fine, then of course the local authority would go ahead and name it and there shouldn't be any problem. Sometimes schools will say, no, really sorry, but we haven't got the resources to meet the needs of this child. The local authority can decide that based on its own assessment, actually the school can meet the needs of this child and go ahead and name it without the school's consent. But under the current regime, if the school disagrees, they have got a right of appeal to the school's inspectorate, I think. And it may be that there's something similar that's going to be introduced under the new scheme. But of course, as parents, if you're faced with a disagreement that the school says, oh no, you know, we're not going to have this child, and the local authority submits to that and names somewhere else that's totally inappropriate, you just go off and appeal to the tribunal, and the tribunal, if it's with you and makes that order, then that's the end of it, really. The school has to admit the child.
Previously, there was talk that academies wouldn't have to admit children with SEN. Has that changed now that academies will be obliged to?
I think special school academies is my understanding that hasn't changed, but mainstream academies will have to admit children. I think that there was a debate in Parliament a few weeks ago, and the concession on that hadn't been made, unfortunately. So I think we probably need to keep a close eye on how that works out. I mean, I'd be surprised if a special school academy wouldn't admit a child, because of course that's what they're set up to meet the needs of children with special needs. It may be because they're oversubscribed or whatever the case may be, but you've still got the option of appealing to the tribunal. Right, so there's no standard format to these EHCPs. A lot of you are probably familiar with statements. They do tend to be typed in a standard format. You've got part 1, 2, 3, 4, 5, 6. But there's no standard format for the EHCPs, although that may change when we get the new code of practice. So it could be that different local authorities have different styles of producing them. There's going to be 20 weeks to complete the process of issuing the final EHCP, which differs to the current timelines, which I'll go on to later because I've produced a table which compares the timescales. It's going to contain social care and health care for access to education and training. I mean, in some respects, it's not really different, I don't think, to the current system, and I'll come on to that later actually, because a lot of you will know, if your child has a statement, that actually health needs are in there already. Social care needs aren't in there, but usually they're in there in part 3 because it's needed to access education. The other good thing is that the tribunal can now consider appeals for children and young people with statements or the EHCP plans up to the age of 25. So you remember I said earlier that once a child has left school and has gone into college, you can't appeal to the tribunal. And I often find actually that a lot of parents coming to me will say, my child has got a statement, they're attending school, but the school only goes up to the age of 16, there's no post-16 provision. I've been told that the only place available to the child is to go to some sort of mainstream college, and I really don't think it's great. The good thing about this is that you can still appeal to the tribunal now, even if your child is at college. So it's a much better safeguard, and you don't need to be worried, I don't think, about the differences between rights of appeal with statements and rights of appeal with learning difficulty assessments. It's all going to come under the umbrella of the tribunal, which I think is really good. There's going to be a duty now to engage in mediation before making an appeal to the tribunal. There are some exceptions to that. I think one of the exceptions that I noted was where there's a straightforward dispute about what school or placement the child or young person should attend in those circumstances. It's agreed that there's no need for mediation. But I would imagine that actually mediation, a lot of parents would be very happy to go to mediation.
Yes, if it's used as a time-wasting exercise when you know actually what the child needs, you just want to cut to the chase. You don't want to sit in a room with people trying to persuade you, stop you, disagree with.
I've been to a few mediation meetings, and although it may not be possible to get the end result, it does help, I think, to narrow the issues so that when you do eventually bring your appeal, you know precisely what it is you want the tribunal to decide. I suppose it can be helpful for that, and of course you've got an independent mediator as well who's not on any one side and there to sort of help parents and both parties really. Personal budget, this is a real hot topic. It's not ever been in existence before for education provision, but this is something that's a new change, which I'll go into more detail on later on. The other thing that I think is worth flagging up, because I think it's quite important for parents to know this, is that under the code regime, children without statements can't be placed in special schools. But under the new regime, children can be placed in special schools without an EHCP. It will be the subject of periodic reviews, so it's not a case where children would just be sent into a special school and be forgotten about. There will be periodic reviews. Now, I don't know how parents feel about this, what their thoughts are, but I can see that there are two arguments for and against, and I think that the for argument is that if a child's education in mainstream school is just breaking down, and I think it picks up on one of the points that a lady mentioned in the session this morning about not being able to access the autism team until the point that the child has really regressed and is a meltdown point. That can be very unfortunate, because then the question is, well, where can my child go? It could take 6 months for a statement, if the child hasn't got a statement, for a statement to be issued. What's my child meant to do in the meantime? And quite often children will get placed in pupil referral units, which aren't the greatest of places, I don't think, for vulnerable children with very significant needs. And so I think that the plus side is that a child can make the quick transition from a mainstream school to a special school, where all of those specialist services are there to either help that child reintegrate back into mainstream school, or where they can be while an EHCP plan is being prepared, because we know it can take some time. So that's the good thing. The possible negative is that it may be that the child is just, you know, sort of in some ways forgotten about, and there's no urgency in terms of finding a permanent place for the child. That's the only thing I can think of. So I suppose we'll just have to wait and see how it works out in practice, but I'd like to think that it's actually a positive.
It's got to be better than the system at the minute, because
Yeah.
at the minute my son is in that situation.
Yes.
He's not registered with the school, hospital from home, education are refusing to take him, and he's just being left.
Yeah.
And it's an absolute nightmare. And every time I make a telephone call, I hit another brick wall.
Mm. Yeah, I mean, that's exactly the sort of thing that I would hope that this would cure, that they are able to go into a special school and build up the transition back to another school, or to even remain at that school. And just to have a totally new set of a multidisciplinary team working with the child on a daily basis, so that there can be a better understanding of what works best for that child, rather than them being at home or a pupil referral unit that, you know, is not really helping. I've just added in here a bit about Children Act services. I don't know if many of you will be familiar with this, but if a child with a disability is in need, they can access services, not educational, under the Children Act 1989. So this could be a whole range of services. They would get a care plan and anything that they need. Usually it's only available until the age of 18, because then after that the child transitions to adult services. The adult services provisions are not especially geared up to meet the needs of children. And a lot of young people with special educational needs, it may be too soon for them to transition to adult services as soon as they hit 18. And so the good thing about this is that local authorities have got a power to extend Children Act services beyond the age of 18, and in actual fact up until the age of 25. Right, so what remains the same? Well, the local authority is the primary body responsible for all of this. The local authority still has the duty to make and maintain and provide what's in a EHCP. There's still going to be the annual reviews, the reassessments, the education otherwise than at school, pretty much most of the things that exist under the current regime. Right, so just a little bit about the EHCP. As I said earlier, it's effective from birth to 25. The focus is on aspirations for the future, as well as the current needs. So when we talk about current needs, what is it that your child needs to be able to meet his or her objectives? And also, what is it that your child needs to be able to be independent so far as they can when they reach adulthood? The other key thing about all of this, which you probably heard about earlier on, is that there's a real emphasis on consulting children, parents and young people to ensure that they're a real part in the way in which these EHCPs are put together. Must be prepared and maintained by the local authority, and a little bit there about what it contains, outcomes, provision, health and social care needs. And I'll go into detail a little bit about health and social care.
Can I just ask a quick question?
Yes.
My daughter, she's got a statement at the moment, she's 15. Would that get changed to an EHCP, or will she keep the statement until a certain age?
My understanding is that the transitional provisions aren't yet available to us, so I don't quite know how the transition is going to be done from statements to the new EHCPs. But one of the points I made earlier was that the criteria for a statement is exactly the same as the criteria for EHCP. And so if your child has got a statement now, they should be getting one of these, subject to what the transition provisions are. I don't know whether, I think it's unlikely that it will.
Just asked Leslie Cheshire this at a previous meeting, and she said that people that are transitioned this year, they won't go on to an EHC plan. I think Eva was there. I think this is 2015, people
Oh, right.
transition, that's when they...
No, I think there will be a phase